I'm attorney Zach Townsend with Pro Legal Care. I've been handling order of protection cases since 2011, and if you have been served with an order of protection, you need to act quickly to protect your rights. If you have been served with an order of protection, it was either granted on the emergency basis or it was denied on the emergency basis. The hearing that occurred was an emergency hearing that occurred ex parte, which means that you didn't have the right to be present and you didn't have the right to be heard, or the opportunity to make your case, or to have notice in advance. That's why the emergency order of protection will normally last 14 to 21 days only. If the order of protection was denied on an emergency basis, you're not out of the woods yet. It still can be granted on the plenary basis. The difference between an emergency order of protection and a plenary order of protection is that an emergency order of protection is short-term and does not require notice in advance. A plenary order of protection does require the opportunity to be heard and advanced notice and can last up to 2 years. Either way, it's a very severe remedy and it's enforceable by the police arresting you. You will be charged with a crime if you violate the order of protection. It's very important that you do not violate the order of protection. Even if the petitioner contacts you first, you cannot respond. If the petitioner calls you, you cannot answer. If the petitioner texts you, do not text back. The order of protection is a restraint on the respondent. The order of protection does not state that the petitioner is not allowed to contact the respondent. It states that the respondent is not allowed to contact the petitioner. If the emergency order of protection was granted, you may want to file a motion to vacate that order of protection. You want to get in probably sooner than 14 to 21 days. This could have implications on your parental rights. This could have you denied your opportunity to have a relationship with your children or even have any contact with your children, because pursuant to the order of protection, having contact with your child, if that child's named as a protected party, would be a crime. That's right, contact with your own child may be a crime. This is extremely serious. You need to take quick action to make sure that you are protected. You should not go to court without an attorney to represent you and to help you through this. An order of protection is not going to provide for the termination of your parental rights, but it essentially suspends your parental rights, and it definitely compromises your parental rights. It can also cause you to not be allowed to access your own children's medical records. It can cause you to be denied your own children's school records. You may not be even allowed to communicate with the minor child's daycare provider. Do not violate the order of protection. Do not contact the opposing party. There really is not an excuse. There's no emergency exception that allows for contact. Don't do it. That includes direct or indirect contact. You can't talk to them, obviously. You can't text them. You can't send them messages. You can't call them. But you also can't post about them on Facebook. You can't Snapchat at them. You can't poke them or wave or whatever the latest social media thing is. It constitutes contact and you can be arrested for it. If you send her flowers, you'll be arrested. You can't have mail. You can't have packages. You can't have third parties communicate with them. You cannot have contact of any kind. Your ex can call you and say they're stranded on the side of the road, they need help, they're out of gas, it's cold, and you cannot go help them because that would be a violation of the order of protection, okay? It's important that you do not violate the order of protection. That's an important part about making sure that it's denied on the plenary basis, because if the emergency order of protection is violated or there's an accusation that there's a violation, that makes it more likely that the plenary order of protection is going to be granted, even if the emergency order of protection was granted on false pretenses to begin with. More importantly, you may be arrested for violating the order of protection. The order of protection might say that you are not allowed to be at the home. There will be restricted addresses. Even if it's your own home, you may have been removed based on the order of protection. You may be prohibited from going to the employer of the petitioner, from going to the school of the petitioner. You may be prohibited from going to certain family members of the petitioner. You shouldn't be contacting the petitioner's family members anyway. That would be considered a violation, potentially, very well may. And even if it's not, you don't want to be dealing with accusations of a violation. Accusations of a violation are sometimes just as bad as the violation. It can derail everything. Even if the petitioner tells you that they're okay with it and that they're going to drop it at the next court date, the parties can't just agree that the order of protection doesn't apply anymore. It doesn't work that way. As long as it's in effect and until it expires or a judge terminates it, it is in full force. An order of protection also provides that your firearms are no longer legally valid. If you have a firearms owner identification card, a FOID card, that would likely be revoked. If you have firearms, they will likely be required to be surrendered. That's right, your Second Amendment essentially no longer applies if you are the respondent in an order of protection case. You may be required to surrender your guns. You may get a letter from the Illinois State Police FOID office that says, give us your guns, give us a list of your guns, or put them in the hands of an appropriate custodian, which may be the better idea, so that way you don't have access to them. Because typically, when you are the respondent in an order of protection, it's going to include provisions that say that your firearms must be surrendered, and if you don't have any firearms, you're not allowed to get any. And if you do have a FOID card, that gets revoked and you'd have to reapply after the order of protection is over with if you want it again. It is very strict. If a person has an order of protection against you, can you get an order of protection against them? Generally, no. The Domestic Violence Act says that it undermines the purpose of the Domestic Violence Act if there are competing orders of protection. There are options potentially for orders that are not orders of protection that provide parameters of communication, but it's almost always going to be denied if you ask for an order of protection and the other person already has one in place. If you've been served with an order of protection, you are in a precarious position. You need help? Call me, reach out to me. We'll set up a consultation, we'll discuss your options, and we'll provide you with your new path forward.